Hello and welcome to the 16th lecture in this lecture series introducing international arbitration practice. In the last lecture, we drafted an international arbitration clause from scratch. The clause covered only the main components of the arbitration clause. In this lecture, we will deal with the other components of the arbitration clause. For this purpose, we use the sample arbitration clause we drafted in the last lecture for drafting the other components. That clause is before you. The changes will be made in track changes mode to point out the additions that we are going to make in this lecture. Our first endeavor would be to convert this clause into a multi-tier clause. So, what are the changes that will be incorporated? First, we will number this clause. Next, we will convert the first clause into a mediation agreement for mediation at Singapore under the mediation rules of the Singapore International Mediation Center. So we will state so the change that we have incorporated is that the dispute would be resolved by mediation by a sole mediator in Singapore in accordance with the mediation rules of the Singapore International Mediation Center. Correspondingly, the arbitration clause is left incomplete. So we add certain components to the arbitration clause as well. So we have completed this clause by stating that if the parties are unable to resolve their dispute by mediation, then the dispute would be referred to arbitration. But the catch is that sometimes the mediation rules that you may select may not provide for a definite time limit for mediation. So in that case, what do you do? So you fix a specific time period within which the first tier will complete. That is 3 months here. But you should also specify from when that 3 months or that definite time period will be computed. Here it is the date of reference to mediation. So if the dispute is not resolved through mediation within 3 months from when the date of reference to mediation was done, then the dispute would be resolved by arbitration. There is also one more advantage in having a specific time limit. That time limit or time frame for the first tier would force the parties or at least would push them to resolve their disputes within that definite time frame. Otherwise, resolution of dispute in the first tier will keep getting delayed. Now, there are two tiers here. The first tier is mediation and the second tier is arbitration. So, correspondingly, the clause regarding the language of arbitration may also require modification. So, we move that to subclause 3 and add here the language of the mediation and the arbitration shall be English. With this, we complete the first other component, that is a multi-tier clause. This clause is good to go as it is, but to complicate the situation further, we would also like to add the accepted matters clause. That is, the clause which provides that certain matters would be excluded from the scope of mediation or arbitration or both. So before that, we'll just make a typographical correction here. Shall be resolved by arbitration. So the clause would read, any dispute between the parties to this agreement arising out of or in relation to this agreement shall be resolved by mediation by a sole mediator in Singapore in accordance with the mediation rules of the Singapore International Mediation Center. If the parties are unable to resolve their dispute by mediation within 3 months from the date of reference to mediation, the dispute shall be resolved by arbitration. Now, there is a practice that while referring to certain rules, whether it is the mediation rules or the arbitration rules, the practice is to add a phrase which is for the time being in force, or simply it could state for the time being in force. Sometimes what happens is that the mediation rules or the relevant arbitration rules gets updated and the institution passes the updated versions of the rules. So in that case, there would be a time lag between the date of this agreement and the date when the dispute could get referred to the dispute resolution process. In the meanwhile, it could so happen that there could be one or two or even more revisions of those rules. So, this phrase for the time being in force conveys the meaning that whatever rules that prevail as on the date of reference of the dispute would apply to the dispute resolution process. For example, if this clause is agreed in 2006 and in 2022 there have been 3 or 4 revisions of the Singapore International Arbitration Center, the revision in force as on the date of reference of the dispute would apply and not an old version. To give you a more practical example, say the unsettled arbitration rules of 1976 was there in vogue for a lot of time. Then in 2020, 2010, sorry, there came a unsettled arbitration rules, which is an updated version. So imagine that in 1980, that is 4 years after the 1976 unsettled rules, parties agreed that the dispute shall be resolved by arbitration as per the unsettled arbitration rules in force at the date of the reference of the dispute. But the contract exists for 30 years or even 40 years, let's assume. Now, in 2011, the dispute arises. So, which would be the relevant rules for reference of the dispute? That is the Unsettled Arbitration Rules 2010, because it uses the arbitration clause, as we said, uses the phrase for the time being in force.